The executive order's stripping of citizenship from U.S.-born children is contrary not only to the 14th Amendment's plain text, but also our common law history, this court's precedent, a federal statute, and over a century of executive branch practice. Every court to have considered the issue agrees that the order is blatantly unlawful, a determination the stay application does not challenge. The government instead argues that Article 3 and equitable tradition categorically prohibit providing non-party relief from the order's enforcement, regardless of the order's illegality or the irreparable harm it inflicts. The government is wrong. It is well settled that preliminary injunctions may benefit non-parties when necessary to provide complete relief to the plaintiffs or when warranted by extraordinary circumstances, both of which are true here. The court should reject the government's efforts to stay a preliminary injunction that maintains a status quo all three branches of government have ratified and operated under for over a century, and that prevent the catastrophic consequences that will result for the plaintiffs and our country if the government is allowed to execute an unconstitutional citizenship stripping scheme simply because legal challenges take time. I welcome the court's questions.
You say the government is wrong about the availability of preliminary injunctions. On what do you base that?
So I think that the two reasons I identified, one, it is well settled, and I understood General Sauer to agree today that universal injunctive relief is appropriate when necessary to provide complete relief to the plaintiffs. That is the case here, and I'm happy to talk about that. But I also, this court has long recognized the availability of universal injunctive relief in extraordinary circumstances where it's justified. I think I would focus particularly on the public interest and equities prongs of the Winter test, and I'm happy to talk about that as well. But I think those are the two reasons the government.
Do you think that if even if one considers the history not to support you, that the pragmatic considerations and the policy considerations should override that?
So again, I would put us in the complete relief bucket. So Mr. Feigenbaum, I'll put on my amici hat in answering that question. I understand General Sauer's proposal to be that we channel all of this through Rule 23. I think that is a historical one. It's inconsistent with the Rules Committee's understanding of the rules. Both, if you look at Rule 23, Rule 65, and Rule 71 together, they establish that Rule 23 is not the channeling mechanism that the government's suggesting. I'll start with Rule 71 because it's responsive, Justice DeBarrett, to your question earlier about whether non-parties can enforce orders. Rule 71 explicitly contemplates that and says if a non-party receives relief, they are entitled to enforce it. I'd point also to Rule 65, the preliminary injunction rule. In 2017, the Rules Committee considered a proposal from Professor Bray to amend the rule to prohibit relief to non-parties. The committee rejected that proposal because it found that it ran afoul of the Rules Enabling Committee. And then I'd end by pointing to Rule 23 itself, which says nothing about it being a channeling mechanism. In Principe v. Scarborough, this court said, we don't treat the rules as excluding background equitable practices. And here, Rule 23 doesn't even contemplate preliminary relief. It's focused on permanent injunctive relief, and I think that's because, as we've been discussing, it's very difficult to get class certification in time to have preliminary relief, so you're doing putative class relief, which is the exact same thing as what's happening here.
Well, why can't you get putative class relief in a preliminary injunction or TRO posture?
You mean, sorry, in the
get relief for a putative class in a TRO or PI posture?
I certainly think you can. The court did that recently in AARP. My point is when the court does that, it's relying on the equitable authority it has to enter that sort of relief, not on the Rule 23 mechanism, because the class isn't binding until after certification, until after final judgment.
If that mechanism is available, whether one way or another, doesn't that solve a large part of the problem in a way that complies with the rules, the problems with universal injunctions that have been identified by administrations of both parties? Go through Rule 23 and do what's needed there, and people are bound then, so that's a wrinkle. But why doesn't that just solve the problem?
Right, so they're not going to be bound until after you get past class certification. So we're talking
I understand
about
that.
And for that reason, I would go to Justice Alito's point earlier that all you're doing is taking the non-party injunctions that are happening now outside of Rule 23 and shoving them into Rule 23. It doesn't address the forum selection concerns. It doesn't address the concerns about the emergency docket.
It complies with the rules. I mean, that the law, we care about technicalities, and this may all be a technicality, but it seems to me the technicality of Rule 23 and the history of that provides, 23b2 provides a mechanism to do what's needed here in terms of getting relief to people. And if you have PIs available for putative classes, that seems to solve the issue for preliminary relief and the timing issue as well.
So B2 provides for permanent injunctive relief. It does not provide for preliminary injunctive relief. Again, Rule 23 does not purport to be the exclusive channeling mechanism. And as I said, the Rules Committee doesn't think it did. So it would be this court kind of projecting its own policy decision to treat Rule 23 that way. And I would come back again to Justice Alito's concerns. That is not actually addressing the court's emergency docket. It's just now we're slapping a label of class certification on it. So I would, and I'll make a second point on that and then say what I think the better way of approaching the problem is, which is I think that General Sauer and I are in agreement that the Venn diagram of cases that are appropriate for class certification and where injunctive relief I think would be appropriate is not coterminous. I think we could pursue successfully class certification here. I heard General Sauer to disagree, and I think it's because they're just different circumstances. If you look at the class certification requirements, commonality, typicality, they were actually added to Rule 23 in 1966, mostly to address the expansion of class certification to include damages suits. That makes sense there. But those were never requirements prior to 1966.
Ms. Corcoran, on the class certification point you've been developing, one response might be, and I just want to get your reaction to it, that by proceeding through the class mechanism, even a putative class mechanism, a court is making a preliminary assessment about who are the parties going to be before it and issuing interim relief so that it preserves its jurisdiction to issue final relief with respect to those parties. And that's very different, the argument would go, than simply saying everybody everywhere, nationwide, universally, or perhaps cosmically, stands to benefit from this decision without ever having to suffer being bound by it. Thoughts?
So I would say, again, that's an ahistorical approach. You haven't had that sort of Rule 23
assume for the moment that we read bills of peace, which I understand to be your best set of cases, to be prototypical of what is now Rule 23.
Right. And so the bills of peace and kind of going through, as Mr. Feigenbaum was talking about, Equity Rule 48 and then 38, in none of those circumstances were we doing this ex ante class certification determination. So the modern class action device actually looks quite different than it was for reparative, not contesting, or at least. Oh, no, I will. I have if I could give an answer, which is that I think it's very difficult, if or not impossible, for the court to do a meaningful in-Ken analysis without taking into account the fact that the government is asking the court to allow it to ignore this court's precedent, to ignore a duly enacted statute, and to upend 100 years of executive branch practice. So I think, although the government has attempted to separate them, that really the merits are embedded in the in-Ken factors.
Justice Sotomayor?
I find it hard to understand how a district court, in looking at a preliminary injunction under the winter factors, where we said that the likelihood of success on the merits is the keystone, how we could separate that out and say the keystone of whether you're entitled to universal injunction is the only merits question because the other factors are not eliminated by winter. You have to balance the equities, and you can't balance the equities without the merits, correct?
I think that's right. I think also, irreparable harm is going to be very difficult for the government to prove if it's not contesting or at least not defending the constitutionality of the order because the government has no interest in enforcing an unconstitutional order. I'd also note there's a quote from Professor Bray in Justice Gorsuch's Texas Concurrence, and it's, "In equity, it all connects." the broader and deeper the relief the plaintiff seeks, the stronger the plaintiff's story has to be. So I think there really is kind of an equitable consideration here of the merits as well that just can't be extracted from the.
Now, the state has explained why it can't pursue class actions. So it admits it's limited to whether it's entitled to complete relief. But how about your organization? You sort of answered it, but I wanted to pin you down on that.
No,
Do you believe that associational organizations can seek class action?
I believe our individual plaintiffs certainly can.
Yes, there's no question.
Yeah, I am nervous about the government's suggestion that it's going to oppose our class certification motion if we were to file one. I mean, class certification can be very discovery intensive. It could be the sort of thing that really delays our plaintiffs from getting the relief that they seek.
Thank you.
Justice Kagan?
I guess what I worry about here, Ms. Corcoran, is that this case is very different from a lot of our nationwide injunction cases in which many of us have expressed frustration at the way district courts are doing their business. And, you know, the typical way in which that frustration emerges is that legal questions are hard.